Serial 6, Mr. Satyavir Bharti.
They are better. They are much better. They are ready with that. They are young company. They are responsible. I don't even say they are junior to me. They are the advocates who are representing. We don't want even those seniorities. Let the state think there should be some representation. Yes.
May it please your lordship, I'll be praying for adjournment because Sri Bharti, he is the panel counsel, my lord, and he has to assist. And
That's no ground, you know that. That's no ground here for seeking a passover. You
My
make
lord.
an effort.
My lord.
You have been arguing cases before
Yes,
this.
yes, my lord.
Let us see if we would require the presence of your senior.
My lord.
Yes.
My lord, this LP has been preferred against the order dated 29th June 2021. Basically,
Please place the order first.
my lord, that is.
Place the order. It is the order is before us. Let us read it together.
Yes, my lord. In the matter of evaluation, the answer script, the board has decided to condemn the petitioner for using unfair means. But the report indicates that there is racket involved in which the examination center, evaluation center are deeply involved.
Yes.
Under the aforesaid circumstances, the court is of the considered view that such manipulation is not possible without the active connivance of the officials and employees of the Bihar School Examination Board, Patna, and therefore deeper inquiry is required in the examination affairs of the Bihar School Examination Board. Accordingly, the court direct the Additional Director General of Police, Cabinet Vigilance to register a case about the corrupt practices and manipulation.
That's all right. We have read that. Now, the order was communicated to the Additional Director General of Police, Cabinet
My lord, we
Vigilance.
are contesting on this ground that this has been directed for vigilance inquiry, my lord. So nowhere we have at paragraph 4 of the memo of appeal, my lord, will see that a gist of our counter affidavit and supplementary counter affidavit has been provided.
Where is that?
At paragraph 4 of the memo of appeal.
Let me go through it.
It starts with that the clear cut stand of the appellant board before the learned single judge in their counter.
Just hold on.
My lord.
But what difference
My
does it
lord,
make?
yes, my lord, what we are contesting is that at no point in time the learned single judge queried from us that what role do we have in the evaluation. Yes, because our counter affidavit and supplementary counter affidavit only specifies the allegations that were against the petitioner and what action we have taken.
Please hear out the court first.
Ma'am.
Now, any idea about this order having been complied with? Has the investigation begun? Has the cabinet vigilance started with the inquiry?
My
I
lord,
think before addressing the court, you should tell the court this. Have you found out?
my lord, that
This order is dated what?
29th June 2021, my lord.
29th of June 2021. 1 year has passed by.
My lord.
It was a specific order of the learned single judge.
My lord.
The copy of the order was directed to be communicated to a senior functionary of the vigilance department.
My lord.
And he was to submit a report in sealed cover by 3/8/2021. So therefore, with this kind of time frame having been given to a police department, they would not have allowed it to go what is that called? Unexecuted, right? So therefore, we need to know whether anything has begun. If something has begun and a report has come or report is likely to come, we will not interfere with the order. But otherwise also, no inquiry could have been made. We are disposing of this writ petition. Otherwise also, just a minute. Unless you are satisfied, we will satisfy you. Though you are supposed to satisfy us, but we will, because in the absence of your senior, we are doing it. Now, the report of the Cabinet Vigilance Department would not be prepared unless they seek instructions from you about your role in evaluation. All right? If it is found that there is no racket involved, it was a singular case of a student playing a foul in the examination hall, then perhaps all this exercise would be useless. But exercise otherwise would instill a kind of fear in the organization, in the evaluating body, in the board of conducting every examination properly. So once this order has been passed and something has proceeded in obedience to the order, why should we cut it short? Why should it be detracked? That's the whole question. In fact, we in appeal would like you to answer that. Unless you say that nothing has begun, it speaks badly of the system adopted by the board, and that board should have definitely been heard before any order was passed. Now we disagree with all that proposed arguments on behalf of the appellant. So
My lord, I have only
find out from the vigilance department, come to us tomorrow
My
to tell us whether any inquiry has begun pursuant to this order.
lord.
If it has begun, we will not interfere with the order. We will only expect a sealed cover report of the cabinet vigilance.
My lord, the purpose of the LPA was that this process should not have taken place. That is the inquiry process, my lord, because our sole contention that we were not asked on this question that whether we are involved or not.
You were required to tell us whether this order was completely left ignored or was it acted upon. Otherwise, you don't have a case, no?
My lord.
Tomorrow. But we have given you our prima facie tentative mind that we are not against this kind of an order. Though if we had passed this order only after hearing the board, but nonetheless, the board has not been castigated in any respect whatsoever. It doesn't offend you. It should not offend you rather. Right? So therefore, no appeal ordinarily, unless you say that nothing has begun. Pass over.
Obliged.
Serial 7, Mr.